We have another blue card now from Mr. Batten. Mr. Moraes, are you willing to already to answer? Okay, Mr. Batten.
To ask you, Claude, you've talked about the lack of proportionality, etc., and we can all agree on that. But the one thing, the elephant in the room, that nobody has talked about this afternoon is the fact that the court cannot look at the prima facie evidence against the accused person and exercise any discretion about whether they should be extradited or not. And we have many constituents who are affected by this, but the most notable case is Andrew Symeou, where I sat through the appeal court hearings and heard the judges. It was obvious from the look on their faces that they realised there was no real evidence against this boy. The evidence was contradictory. The statements appeared to have been concocted by the police, and in no way he should have been extradited. How would you address that problem of the fact that the courts cannot take into account the prima facie evidence or lack of it against an accused person?
Thank you. The question is clear. I hope also the answer will be clear.
An arrest warrant, there has to be prima facie evidence. You cannot execute an arrest warrant without judiciary understanding what the simple facts of the case are. In the Andrew Symeou case, the deeper problems, which I say to Gerard Batten, were the procedural problems, the detention periods and the court system in practice after the arrest warrant was executed. You talk about the appeal procedure, so it was the period after the execution of the arrest warrant which was problematic and which we are trying to fix today in this debate.